certification of witnesses. Pursuant to Giglio under advisement, I've read the case. I don't know that it requires them to deny the motion because it doesn't require them to make any specific certification. However, under Brady, they have the affirmative duty to notify you of any deals or agreements with witnesses or anything of that nature. So if they don't comply with that, that's a Brady violation. But I don't know that I can make them go down each individual witness and say we don't have an agreement or we have an agreement. If there is an agreement, they have an affirmative duty to notify the defendant of that.
Your Honor, I can state that none of the law enforcement witnesses have any Giglio issues. None of the civilians, most of them do not have any record whatsoever. One witness has a DUI from, I think, 30 years ago, so nothing that would be relevant to any sort of impeachment.
All right. And also, the motion to exclude the physical evidence per Giglio, I didn't see that that was applicable, so I'm denying the defendant's motion in that regard. Now, as to review of the transcript.
There are no material errors in the transcript of the audio portion of the interview.
All right. What is your position on allowing the defendant to use the transcript to...
For impeachment purposes, but not to enter as an exhibit.
All right, we'll go with that then. All right.
Your Honor, the question of the letter, Detective Susi did bring the original letter with him this morning, the handwritten statement from Mr. Dontel.
Oh, okay.
I showed it to Mr. Preston Britton. I made another copy of it and also copied the bottom of the pages that he said were cut off. So I believe that we are fine on that.
We are, Your Honor.
All right.
And then, I'm sorry, one other issue, Your Honor.
That's fine.
There were several stipulations by and between counsel to chain witnesses. I have signed stipulations that were filed with the clerk of court. What the state would propose is that when it comes time, sort of in our order of witnesses, that stipulation would be appropriate, that I be allowed to read it into the record. It's been filed, so I'll sort of leave that to your discretion.
I'll leave it up. Well, first, is there any objections one way or the other on that?
I think we would oppose that, Your Honor. I don't think we want it in evidence.
And that's fine, I think, as I'm
As
thinking
long
that
as it's on the record.
It's on the record, and, yeah, I'm fine with that.
Okay. All right. Anything further from the state?
I don't believe so, Your Honor.
Anything from the defense?
Yes, sir. Under Rule 615, we'd like to question the witnesses, Your Honor.
All right. Any objections?
No, Your Honor, I do have a statutory victim in the courtroom. The other civilians are not testifying. Detective Susi is our law enforcement lead, and we would ask for reciprocal sequestration of any defense witnesses.
All right. So, all right, who's the lead investigator?
Detective Susi, S-O-U-C-Y.
S-O-U.
C-Y, like saucy but with an O.
All right. And any victims?
Yes, Your Honor. Savannah Rice is present in the courtroom. She is the victim's daughter, oldest daughter.
All right, so Detective Susi, Savannah Rice, and the defendant will be allowed in the courtroom. All of the witnesses are sequestered. I'm leaving it up to the attorneys to make sure you do not have a witness in the courtroom, because I can't identify all of them, I don't know. So if there's a witness who's in the courtroom outside of these three, they're not going to be allowed to testify if they're in the courtroom, okay?
Yes, sir. And Your Honor, we would also need, given that it's being televised, an order from the court instructing those who've been sequestered not to be watching this elsewhere.
Yeah, what we need to do to make sure there's where the where the witnesses are going to be awaiting their testimony, don't allow any electronics or anything.
We could go into the criminal
Yeah, we'll have courthouse security monitor, make sure there's no electronics in there.
Okay, I'll tell you, we have a couple witnesses in the state anteroom right there, and I'll have our helpers, our assistants just advise witnesses not to watch the news or anything.
Well, no, I mean, I want to, because I've had this come up in past trials, no electronics, no phones, no computers, no TV sets, nothing in the witness waiting area, okay?
That's fine.
All right,
Thank you, Your Honor.
all right. Anything else from the defense?
Yes, sir, Your Honor. There was one motion that we think we failed to mention yesterday, if the court would hear it, just related to some physical evidence and picture evidence of guns, Your Honor. I think that'd be improper in this case. They don't have a murder weapon in this case, Your Honor. The defendant did own guns, but any effort to put those into evidence we think is improper. I think it's improper effort to try to characterize the witness in a manner that is violates their constitutional rights to own guns.
All right, what's the state's position?
It's a shooting death, and the guns that we intend to introduce are the same caliber as the bullets that killed Mr. Rice. They were submitted to SLED for examination. They are certainly relevant. We did not bring in every gun that the defendant owns. And quite frankly, our information is that we don't have a murder weapon because she threw it in the intracoastal waterway. So the two guns that we have, that we intend to introduce, are the same caliber as the bullets that were recovered from Mr. Rice's body.
But what does the ballistics show? Were they the guns that fired the bullets?
No.
And what is the relevance?
To show that it's still part of the investigation because they saw guns that match the caliber. They're submitted to SLED to determine whether or not they're the murder weapon, and they are not.
Well then, what if it was a bazooka? You know, the bazooka, but the bazooka wasn't used to kill the defendant because it's the same caliber. If it has been excluded as a murder weapon, then what is the relevancy of putting the picture into evidence if for no other reason than to tell the juror
Not relevant, quite frankly.
So you're saying that every person that owns that caliber of gun would be a suspect?
Not unless they have the same motive that this defendant did.
Okay. Now, if you've got a picture of a gun that your testing has shown is not the murder weapon,
We have the actual gun is because the SLED examiner needs to look at that and say, he cannot testify that it's excluded unless he sees the actual gun and says, yes, I recognize this firearm. Here's the SLED lab number. Here are my initials. Here's the SLED item number. I looked. This is not the murder weapon. I don't see how that's prejudicial if we're saying it's not the murder weapon.
well, if I have a gun, it's not prejudicial for you to put it in, but it's not relevant either.
You're not the defendant.
I know, and I understand that, but what I'm saying is I don't see the relevancy of putting in a picture of a firearm that is not involved in the crime.
So it's not relevant that we were able to exclude two guns as a murder weapon.
Why do you want the jury, are you going to put in every weapon that was excluded?
There were only two that were excluded because there were only two that were the same caliber. As I said, they did not seize every weapon that Ms. Jackson had. They only seized the weapons, and the only weapons that were submitted to SLED were ones that possibly could have been the murder weapon.
But
that
ultimately were not.
Right, but that's part of the investigation.
Well, you can say that.
But the SLED analyst will not testify unless he sees the guns. They can't do it because they can't definitively say, this is the gun that I tested.
Well, they can testify that they did not test any guns that proved to be the murder weapon without putting a photograph of the gun in.
It's the actual gun. I have a photograph of the person who recovered it, but we have the actual guns. The SLED analyst doesn't look at a photograph and say, no, that's not the weapon. They look at the actual weapon. They test fire those weapons, and then they...
But you have the actual gun that is not.
Yes.
Okay, I'm going to grant the motion to exclude pictures of the guns. I don't see the relevancy. There has to be a relevance, and you have a firearm that is not part of the crime.
Well, Your Honor, you are substantially crippling the SLED witness's ability to testify.
That, why can't he testify, I tested the guns provided by police and none of them were the murder weapon?
Because that's not how, SLED has very exacting standards of how they testify. He needs to be able to say, yes, this is the weapon that I examined. And if you're excluding photos, that's fine, but as I have said, we have the actual weapons that he testified and compared against the bullets.
Well, the basic premise is that evidence must be relevant to the case. And I don't see where a firearm that was excluded and is not part of the murder weapon, it's not part of the crime, it's not in any way associated with the death of the victim, is relevant in this case, other than to show that the defendant owned firearms.
No, it's to show that the investigators conducted a thorough investigation.
Well, you can do that without putting the gun in, saying, yes, we recovered guns, yes, we found guns, we had them all tested, none of them were the murder weapon.
And that is somehow less prejudicial than showing a photo and the actual two guns that were tested and excluded.
Yeah.
So I can have an investigator say that they found 20 guns in her closet, they recovered 2, and those were not the murder weapons.
Exactly.
Okay, I was trying to limit the...
You were trying to get in a physical thing to show to the jury that said this defendant owns guns. This is the same caliber as the one that killed the victim, so therefore the defendant must have killed the victim.
No, that's actually not what I was doing, Your Honor. Part of a thorough presentation, especially with SLED witnesses, is that we present them with everything that they examined. I have done this in innumerable trials, and there are plenty of times when it is not the murder weapon. I did it in the Samantha Raven trial, where we had a gun that was recovered and it was not the murder weapon. It is part of the investigation. It's part of the res gestae of the investigation. And so essentially you are crippling the SLED analyst's ability to testify because he needs to see what he actually examined.
I think he can testify without saying that whatever Horry County law enforcement brought to SLED for testing was not the murder weapon.
Okay, but if I understand Your Honor's ruling correctly, I can have my witnesses, which I was not going to, but now I will, testify that there were X number of guns in the defendant's home. They seized 2. Well, they seized 3, but they submitted 2 to SLED.
Right.
And those were not the murder weapon. So the state is not precluded from saying how many guns she actually had.
I don't know that there's still a relevancy issue.
That's right.
I mean, what you're trying to do is paint the defendant's guilt based upon the fact that she owned guns.
I'm not, Your
And that the
Honor.
defendant was murdered
No, it's,
by shooting.
Your Honor.
I understand your argument. I made your ruling. My ruling, let's move on. The photograph does not cut it.
Thank you, Your
All
Honor.
right.
And that's also the physical evidence of guns as well, Your Honor.
Do what?
The physical, that's also, your ruling also extends to the physical.
I don't see the relevancy of a firearm that's not involved in the crime being relevant to the case. If it was not the murder weapon, it was not fired, it was not used to kill the victim, and the defendant is on trial for murdering the victim. I don't see the relevancy of any firearm or any weapon that is not the murder weapon being used.
Thank you, Your Honor.
All right?
I have had a chance to look at Detective Marcus's, presentation or report. If we would like, I can hold off and make this argument later so we can get started. If you'd like to hear from me, we discussed it yesterday. They provided me a report
It's a
of
presentation.
his presentation for his Cellbright presentation.
All right, let me hear from you on that.
Okay, so Your Honor, this is, now that I've had a chance to review this, it's an attempt to summarize the testimony and essentially present a closing statement through a witness. They are going to offer him as a digital forensics expert, is my understanding, and I can challenge those qualifications at a later time. But even if you accept the principle that he is a digital forensics expert, they have included in here things such as surveillance still shots from a restaurant. That has nothing to do with CellHawk data. That has nothing to do with GPS location data. That is a picture of a witness and a co-defendants eating dinner. They've added into this license plate readers. Well, Detective Marcus isn't an expert on license plate readers. It is a summation of the entire case in a packaged form, stamped with the name expert on it, to be presented to the jury. And it's just
So what
not.
are you asking?
I'm asking you to suppress or prevent her from showing demonstrative evidence that is outside the area of his expertise and can confuse and mislead the jury.
All right, what's the state's position?
Well, Your Honor, I don't believe it's stamped with expert, but what Sergeant Marcus does is he uses other items of evidence, which will already be in evidence, to validate the fact that, say, CellHawk, based on the longitude and latitude contained in the defendant's cell phone records, they say she was at point A. In order to validate that, so I am not just willy-nilly saying defendant was in point A, here is an LPR tag reader saying she passed by this area. Therefore, that helps validate that she was here. There's a picture of the defendant in Abuelos on her phone. There's geolocation data that shows that her phone is in that location. So it's going to validate the data that was provided to the defense long ago. Because I guarantee you that if we just had someone coming up and saying, cell phone data, how's her there? Well, how do you know? This is a way to validate the very records that we have provided.
All right, anything in reply?
Yes, sir, Your Honor. Again, that's what makes it even extra dangerous. Because if it was just GPS, maybe I could understand that. But this is CellHawk data, which requires someone to testify who is an expert about how wide those ranges are. So on the one hand, they're saying that they're going to present evidence that shows a cone, the conical shape of where a person could be based on that cell phone data. And then they're going to show a picture to say, oh, look, they're together. And so that can mislead the jury to think every time there's a CellHawk ping, that means the two of them are in close proximity. But a wide range, Your Honor. So that makes it even more dangerous and more misleading to the jury.
All right, I'm going to deny the motion. I think the expert report is.
Your Honor, just real quick. This goes to my point, which is, this isn't something I've had before. This is something I got yesterday. I do believe it is a report.
I've made my ruling. Now, that's the first thing I need to lay the groundwork. When the court makes a ruling, that's the end of the arguments. Don't keep arguing your position.
Yes, sir, Your
All
Honor.
right? Anything else?
Yes, sir.
All right.
Oh, wait.
All right, let's bring the jury. Okay, hold for a second. Tell them to hold up.
Luke, stand up.
I think we got enough. All right.
She's got
Let's go ahead and get them to bring them in here. Got a request for the jurors wanting to take notes, so I'm going to allow them to take notes, but I give them some instructions on note taking. this morning. That's great assistance to the court. I want to thank you for being on time, and I apologize for keeping you in the jury room for so long. Now, we are getting ready to start the trial of the case of the state of South Carolina versus Meagan Marie Jackson. I've got some preliminary charges I need to give you before we get started on that case. I understand, Mr. Roberts, you have been selected as foreperson, is that correct?
Yes, sir.
All right, thank you for serving in that capacity. If you'd always occupy the seat where you now sit. The alternates, if you would always occupy the alternate seats unless you become a part of the 12-pound jury. As I told the rest of you, you're at liberty to sit in whatever seat you like, whether you alternate seats, use the same seat, or whatever makes you feel more comfortable. As I also told you during jury qualifications and during voir dire, jurors, just like witnesses, are constantly taking oaths. So I'll need all members of the jury to please stand and raise your right hand while the clerk administers the oath for you to serve as jurors on this case.
Do you solemnly swear or affirm you will well and truly try the issues joined in this case and a true verdict rendered according to the law and evidence, so help you God? Yes. Thank you. You may be seated.
All right, is there any member of the jury that did not respond to the oath by saying I do or yes? If so, please stand. Thank you very much, ladies and gentlemen. Now, we're getting ready to start the trial of the case of the state of South Carolina versus Meagan Marie Jackson. Now, I know from watching TV shows, movies, reading books, things for entertainment, trials are usually full of a lot of suspense, a lot of action. While that might be the case in this trial, it probably won't be. I think what you're going to find is that trials are often slow, repetitive processes, the exact opposite of what you might be accustomed to when you read about trials or watch trials for entertainment purposes. But I hope you do find the trial entertaining. I hope you find it educational, and I want to thank you from the outset for serving as jurors on this case. Now, the attorneys appearing before you are advocates for the parties they represent, but first and foremost, they are officers of the court. They're sworn to uphold the integrity and the fairness of our judicial system and to help you in a search for the truth. You should expect them to be professional, competent, and ethical in the representation of their client's interests. What I now say to you is intended to serve as an introduction to the trial of this case. These remarks are not a charge on the law of this case. I'll instruct you on the law applicable to this case at the end of the trial before you retire to consider your verdict. This is merely an explanation of the procedure that we will follow in the trial of this case so that you can better understand what might be happening. Now, the defendant is charged by two indictments, one charging the defendant with murder and one charging the defendant with criminal conspiracy to commit murder. Now, I'll explain the elements of those crimes to you at a later time. What you need to know now, though, is that these indictments are simply the charges by which this case is brought into this court. They are not in any sense evidence of any of the allegations contained in them. The defendant has pled not guilty to these indictments, and therefore the state has the burden of proving each element of each indictment beyond a reasonable doubt. It will be your duty, ladies and gentlemen, to decide whether or not the state has met that burden. Your purpose as jurors is to find and determine the facts of this case. You're the sole judge of the facts of this case. If at any time I make a comment regarding the facts of this case, you must disregard my comments. You are to determine the facts of this case from the testimony that you hear in any other evidence that is introduced during the trial of this case. It is up to you to determine the inferences which you feel may properly be drawn from that evidence. It is especially important that you perform your duty of determining the facts diligently and conscientiously, because ordinarily there is no way to correct an erroneous determination of the facts by a jury. On the other hand, and with equal emphasis, the same law that makes you the judge of the facts in this case makes me the judge of the law. The law is given to you by the court is the only law that you may consider. You must accept and follow the law as I give it to you, even though you may disagree with it. Just as I cannot tell you what the facts of this case are, You cannot disagree with me about the law to be applied in this case. Your job is to take the law as I give it to you and apply it to the facts as you find those facts to be from the testimony of witnesses and any other evidence that is introduced during this trial. After doing that, you will then render your verdict, a true and just verdict under the solemn oath that you just took as jurors. Now, until I advise you to begin your deliberations, you must not discuss this case with anyone, including your fellow jurors. Don't discuss it with any friends, family members, or anyone involved in the case. After the case is submitted to you, you can then discuss it, but only in the jury room with your fellow jurors. The attorneys and parties in this case have been advised that they're not to talk to you at all, so they're not being rude. They're just following the instructions of the court. During the trial, you're not to read or listen to or watch any news reports about the case. This includes anything that may be in the newspaper or on the internet, the radio, or television. You must not consider anything you may have read or heard about the case outside of the courtroom, whether that be before or during the trial of this case. It is important that you keep an open mind and not decide any issue in this case until all of the evidence has been presented to you. The parties have made their closing arguments, and I've instructed you on the law to be applied in this case. It is your solemn responsibility to determine the guilt or innocence of the defendant, and your verdict must be based solely on the evidence as it is presented to you in this trial and on the law, as I instruct you during and at the close of the trial. Now, in just a moment, the solicitor will make what is called an opening statement, in which the solicitor will explain to you the issues in this case, or at least what the solicitor thinks the issues in this case are. The attorney for the defendant may also make an opening statement, although he is not required to do so. What the attorneys tell you during their opening statements is not evidence in this case. It is only their contention as to what the issues in this case are. The evidence in this case will be presented to you by testimony of sworn witnesses from the witness stand and any other exhibits that may be introduced into evidence. Now, in determining what the true facts are in this case, you must decide whether or not the testimony of a witness is believable. It is my responsibility to rule as a matter of law as to whether certain testimony is admissible at all or not. But once testimony is admitted into evidence, whether or not you believe it is solely for you to determine. In deciding whether to believe a witness, you have the right to consider the interest of any witness, the bias of any witness, the prejudice of any witness, the opportunity for the witness to have seen the matters and things about which the witness may testify, and the way the witness acts on the witness stand. You have the right to consider anything that is in the record that will help you evaluate the testimony of the witnesses. That means that it is your duty to pay close attention to these witnesses, to observe the witnesses, to listen to the witnesses, and pay close attention to the attorneys and to the court. Don't let your thoughts wander, but give strict attention to the testimony in this case, so that at the end of all of the testimony, after the arguments of counsel and a charge on the law by the court, you will then be in a position to determine what the true facts are and apply the law to those facts, and thus render a true and just verdict. Now, I understand that some of you have asked to take notes during the trial of this case. I will allow you to take notes. However, I must give you some instructions on note-taking. First of all, your notes are personal to you and cannot be shared with anyone. So the clerk of court is going to provide you with a pad and either a pencil or a pen or writing instrument. The first thing you need to do is to write your name on the first sheet of that pad. And make sure you use your pad every time and you don't share it with anyone. When you leave the courtroom, take a break or whatever, you'll need to leave your pads in the jury box. When you return to the courtroom, make sure you have your pad and no one else's pad. Next, don't try to write down everything that is stated by a witness. You're going to miss some testimony. The purpose of note-taking is to jot down a note to refresh your memory as to a matter that you think is important. If you try to write everything a witness says down, number one, you're not going to observe the witness. And number two, you're not going to be able to keep up with the entire testimony. But if a witness testifies to something or an exhibit is introduced into evidence
and you want to make sure you remember that at a later time, just jot a quick note to refresh your memory. And then finally, note-taking is not required. Some people are better note takers than others. Some people can recall testimony and evidence without taking notes. So do not feel that you are required to take notes. You're not. It's up to you. It's a personal decision for you to make. All right, I'm going to go ahead and have the clerk of court hand out the pads, the writing utensils, write your name on the first page, and as I said, if you choose to take notes, just use it to refresh your memory.